are self-represented. Mr. Andrews is appearing as the court trustee. Frankly, Mr. Andrews, I didn't know you were going to make appearances in these cases. I figured you would just submit a worksheet to the parties for them to file with a limited appearance, but I appreciate you being here. Are the other judges requiring your appearance?
I don't know that there's been anyone who's set a requirement or not, but I kind of felt like if I'm submitting a proposed worksheet, I should probably appear just in case there's any questions about the number or how it was calculated. And
Okay.
oh,
Well, okay, I appreciate that. Actually, I think there might be a couple things that come up, but I still don't think it's something necessarily for you to resolve, other than sometimes it's nice to have an attorney's thought and input about procedural things. But anyway, the first thing I noticed with your proposed divorce decree and divorce agreement is that there is a house in Whitewater, but you mark no to is title to real estate involved. So I'm going to have to, I'll correct that to yes, there is title to real estate involved. Because you own a house in Whitewater, right?
correct.
And you're both on the mortgage. Okay. And Mr. Staggs, are you the one taking the house?
Yes.
And Kimberly, do you live in Douglas? Is that right?
Yes.
Okay. So Alexander, you're taking the house, but you're gonna have to refinance it eventually. So Ms. Staggs can get off the promissory note. And then I can award it to you in the divorce. But I would suggest that you do a quick claim deed. And you do that to free her of any responsibility or liability once you get it refinanced. Okay?
Okay. Yeah.
Because she doesn't want to be off the deed necessarily until she's off the mortgage. She doesn't
Right.
want to not own the property, but still be responsible for the payment. And I try not to give you legal advice here, so I'm not giving you legal advice, but Kimberly, you need to understand that until you're off that mortgage, whether you live there or not, it doesn't matter who I awarded it to, they can come after you if there are payments that are missed.
Okay.
I can't undo pre-existing contractual obligations, whether it's credit cards, whether it's a mortgage, whether it's a car payment. I can award things to people and find them in contempt potentially in the case, which could subject them to fines or jail time. But frankly, that doesn't happen very often. But that's my only enforcement power. I can't undo what's already been done through a lender or anyone else contractually. Okay.
Mhm.
The other thing is it looks like to me there's potentially about $40,000 in equity in that house. And of course, Kimberly, you would be entitled to potentially, again, I don't want to give you legal advice. That's the hard part with you not consulting with counsel and doing these things on your own, even though you have a right to, and I respect that. You're not always understanding what you're entitled to, and then after it's over, it's too late. Once I enter orders about property, I no longer have any jurisdiction to modify it down the road, even if it was unfair. Now I'm supposed to make a fair, just, and equitable finding, but I can only do that based on facts I have before me. And so I'm only looking at what you've written down as far as the value of the property and what you owe, but it looked like maybe you owe 114,000, it may be worth 150. So that may not be a full 40,000, but split two ways, it'd be $20,000 that Kimberly, you would be entitled to. Now, people make agreements all the time, and they'll do that if the children, like, they're gonna primarily be, I think their base is going to be with Alexander. So some people will make concessions because they don't want their kids to lose their home, or they've just entered into agreements for lots of reasons. And so it's not that it has to be equal, 50-50 across the board, but you ought to at least know what you're giving up and what you're potentially entitled to. You guys didn't list any retirement. Now, I know you've only been married 7 or 8 years, so that's only 8 years worth of accumulation. But if Kimberly has 401 through Dylan's or retirement, technically you two are entitled to whatever you've accumulated through your employment as well, potentially. And then lastly, I don't see all your debt listed as to who's paying what. The car loan, usually a car loan does go with the car. There's usually not tons of equity in vehicles. Usually what you owe on them is about what they're worth, if that. So usually you do just take your car loan with your car, but there's some other debt there that, like Capital One, have you paid all of that off?
I think we each have our own cards with our own names on them. They weren't joint.
Okay. So there is not any joint debt.
Outside of the house and the car, no.
Okay. And again, you may want to refinance. If you have your own car, you may not care as much. But you're not probably going to be able to go get a loan on another car or get a house loan and buy another house if you're already on these marital loans. Okay, well then I'm not going to worry about the rest of the debt. What I saw in here, I was concerned that some of this was joint debt, but okay, very good. All right. And it looks like, I guess, Josh, I wasn't sure. I was going to ask them why there was an amended worksheet.
I think that the first one, and I don't have it. There was a mistake on the first one. It was just, but I had already filed it.
Sure.
If I remember right. So, I don't remember what the mistake was, but,
It listed one child instead of 2 on the first sheet.
that was it. Yep. That was it. It was just an oversight. So,
Okay. So mom owes dad $532.
yes, that is correct.
Okay. And Kimberly, do you want to proceed today? Do you want to consult with an attorney? What do you want to do about any potential equity in the house that you might be entitled to?
We can proceed.
Did you buy the house together, or did one of you own the house before you got married?
We bought it together.
Okay. The question I was going to ask you, Josh, out of curiosity, and again, I don't want to act as their attorneys, is have you ever had a situation where, let's say there's $18,000 in equity in a house that somebody's entitled to, and she owes $500 a month in child support. And I understand that child support is for the children, that can't be negotiated away necessarily. But let's say for 3 years, she was being credited for the child support to an amount of $18,000, which equated to what he maybe could have been ordered to pay her for the equity in the house. Have you ever, I've not done that, I don't think.
I have done offsetting judgments before. And I'm confident in including with child support where it was specified that the amount of child support would be per month, but it would have to be structured in a way that, because child support is modifiable with material change in circumstances, the way that I've done it is you specified the amount of the equalizing judgment and then said that it will be, party A will pay using
Right,
an example, $532 a month towards the equalizing judgment. And then party B will pay $532 per month for child support, and that will offset completely.
right,
But the order would need to be clear on that.
right. So like, I wouldn't want to do it with a 4D case, but say an attorney comes in and institutes child support to be payable, then whatever wasn't credited is still owed as a judgment. So you have to word it and craft it that way, or because anybody can come in at any time and say, well, I didn't ask for child support, but now I need it.
Right.
Okay.
And I think you would also have to address the fact that the equalizing judgment, unless specifically stated otherwise, would accrue interest on it. So that if you're making monthly payments instead of being paid in a lump sum, either interest would be accruing or the court would waive that interest. But
Right.
if it's not specifically waived, then it accrues as a matter of law.
Right, right. Okay, all right. Okay, Alexander, would you raise your right hand? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Please state your name.
Alexander Staggs,
And where do you reside?
212 North Oak Street, Whitewater, Kansas.
All right, is that a residence that you own with Kimberly?
Yes.
Okay. And that's in Butler County, Kansas?
Yes, ma'am.
And were you a resident of the state of Kansas 60 days prior to filing for this divorce?
Yes.
All right. And let's see here, I always have to check. I'm sure 60 days is elapsed. They don't put the petition on the bottom anymore, so I have to hunt for it.
Your Honor, I could tell you that I filed my amended child support worksheet in April, so which would have been after the petition.
Okay, so 60 days has elapsed since the filing of the divorce. When were you married?
We got married June 12th, 2017.
Okay. And since that time, have you separated?
Yes.
Did you separate in March of this year?
Last year. Yeah, March of last year.
Okay, so March of 2024?
Yes.
Okay. And since your separation, have you come to the conclusion that you're incompatible with irreconcilable differences? In other words, you're not going to be able to reconcile and live together again as husband and wife.
Correct.
Okay, and you're asking the court to grant a divorce today.
Yes.
All right, how many children have been born of this relationship?
2.
And can you give their name and ages, please?
Andrew Staggs, 7. Alice Staggs, 4.
And the two of you have entered into a parenting plan,
Yes.
and that's one essentially where you keep the children at the residence in Whitewater every night.
Yes, so they primarily reside with me. Kimberly watches them for a couple hours after school until I'm off of work. And then because she doesn't have set days off of work, she gets them on weekends when she's available and holidays as scheduled.
Okay, I don't think there's anything in the parenting plan about holidays, so you need to. So it's by agreement.
Yeah.
Or. Did you
I've got on my,
supplement,
oh, sorry, go ahead.
did you supplement with the holiday schedule?
In the initial paperwork, I know I had filled out, like, on Halloween, even years they go to me, odd years they go to her, Thanksgiving, vice versa, birthdays. I have them on my birthday, she has them on her birthday, she gets them Mother's Day.
Okay.
That
Okay.
was with the initial filing.
Oh, in the proposed, okay.
Yeah.
All right, and where do they attend school?
They go to Remington Elementary School. Over in Potland, Kansas.
Okay, does she pick them up after school, take them to her house in Douglas, and you pick them up there?
They ride the bus back to Whitewater, and then she watches them at the house for a couple hours until I get home.
Okay,
We're on good terms. It's been pretty cordial, everything so far.
all right, well, that's good, and it's been over a year, so that's pretty good. It's just, as I tell people, when third parties enter the mix, people remarry and all that kind of stuff.
Yeah.
They move or, things change, but the court has continuing jurisdiction of the children and the parenting plan for any motions if Kimberly's seeking more time or more overnights or that kind of thing, but it is best that you get along. Okay. Neither one of you are active duty military, correct?
Correct.
I always assess cost to the person that filed. You're not asking Kimberly to reinstate your maiden name or former name.
No,
Okay, so you're keeping your name. All right, and we talked about the agreement with the real estate. And Kimberly, do you think him keeping the property without paying any equity payment to you is fair, just, and equitable?
yes, I do.
Okay, and I assume you do too, Mr.
Yeah.
Skaggs, all right. And then the 2011 GMC, is that what you're driving, Kimberly?
Yes, it is.
Okay, and you're gonna take that in the loan. And then you've got the property description here at 1212 North Oak. And Kimberly, it's been marked here and you've signed off on this journal entry, correct?
Yes,
Okay, and you're not currently pregnant, correct?
correct.
Okay. And do you believe that this current arrangement with your children and the amount of time that you're seeing them and the circumstances is currently in their best interest, Kimberly?
Currently with my work schedule, yes, it is.
Okay, and Alexander? You believe it's in the children's best interest how you're working this out currently?
Yeah, given the circumstances, yes.
Okay. Kimberly, which Dillons do you work at?
Central and Rock in Wichita.
Okay. And it's joint custody. Now, what I'm supposed to do, Kimberly, is I'm supposed to authorize an income withholding order. And they send that to Dillons, and the $500 a month or whatever it is, So the guidelines are pretty well just set out. And the attorneys have computer programs and they plug the information in and it is what it is. I mean, there's not a whole lot of discretion with it. So it looks like it's got you paying I'm having trouble with this worksheet here. That's because I think that's the DRA. And then here's the worksheet. So it looks like the worksheet has you paying $532 a month. You understand that?
Yes,
What that will be paid through the Kansas Payment Center. To make sure there is a trustee fee for collection purposes. If it should go unpaid, then you don't have to hire an attorney to collect it. It's actually what pays Mr. Andrews to help with cases and enforce child support through the court trustee's office. And it's a percentage that's added on there that has to be paid. Everybody doesn't. Nobody likes it, but everybody has to pay it. But the important thing about KPC through Topeka is there's never a question about, is child support being paid? Is it being credited properly? And frankly, most judges don't want to sit down and look at a period of several years and receipts and groceries and checking accounts and go back and try to reconstruct whether or not somebody's paid what they're supposed to be paying or not. So that is just a method that it's ensured because it's in the public's best interest as well as children's best interest for people to support their children and pay their child support. So that's how it's set up. And it also comes with an income withholding order. Unless there's a really good cause not to issue it, we're supposed to issue them. Dillon's is quite familiar with that. And that's kind of the whole point of the requirement of income withholding orders in Kansas. And really, it was sort of a federal push to do this so that all employers were doing it for lots of people. So no one was being mistreated at work, so to speak, because, hey, you've got a wage garnishment, you've got an income withholding order, because it's just standard. It's the exception not to have one. And so they set up their payroll to be able to do these things. So, and then again, the state never has to worry about somebody running behind on their child support or not paying it here and there because it's coming right out of your check. So usually they break it down. If you get paid twice a month, they break it up that way. So they don't just take it out of one paycheck. They try to equally take it out. But I will have to order payment through KPC and authorize an income withholding order. Okay. But that's what I'm supposed to do. All right. Joint custody means you both have access to all the information. You're supposed to communicate with each other. There's stuff in here about that. If you're going to move, you have to give notice. If you have any questions about what your obligations are, look at the statute. It's very specific on certain things that you have to do or that you can't do, even though it's joint custody, as far as moving to another state and that kind of thing. Okay. And to me, it's stuff that kind of be common sense with parents. I think that's probably about it. Neither one of you are seeking spousal support or what we used to refer to as alimony. Is that correct?
correct.
Okay, well, there's not a huge disparity in income. It's not a long-term divorce. You don't have tons of assets or businesses, so it's probably appropriate. I'm not concerned about not ordering it. So. All right. Now, alternative dispute resolution, you wrote down Tina Snell, and then I think you said that's Alexander's mother or something. She lives in Lawrence, or what? Who is she?
She's my mother. She lives in Bartlesville, Oklahoma.
Okay, okay. So I don't want to mess with your journal entry that much. You've done a nice job and typed it up. But what it's meant is people have agreements that, hey, if we get sideways or in a disagreement about something with the children or parenting time or whatever that you're arguing about that you can't agree to, we're gonna go to mediation first. We're gonna seek a third party that specializes in mediation to help us resolve this issue before we just file custody hearings and motions in court. And if it's in your order, then you're bound to do it before you file a motion, or your motion can be dismissed. Okay? So I'm either going to have Amy white this out altogether, or there is the following dispute resolution method. I can put her down as a third party contact for you to resolve issues, but it's not common to do that. So how would you like me to handle that? Just not have any mediation at all? I think I'm gonna do that. I'm just gonna wipe.
Yeah, I was gonna say, we came to that solution because, I mean, we have known each other for a majority of our lives. Her mom's very neutral
Okay.
has been very neutral on the whole process. And neither of us, we haven't had any reason to speak with any lawyers, or like, so we didn't really
Okay.
know, like, who
Okay.
would we even.
All right, well then I'll mark the following, instead of or, I'll mark out or, I'll mark the following dispute resolution method. And I'm gonna put consulting through maternal grandmother. So what I'm gonna ask you to do is that if there's something that you don't agree on, whether it's how much you spend on clothes or what extracurricular activities going on or whatever, then you call her and you say, what do you think's in so-and-so's best interest? What do you think's in the children's best interest? Because I assume that you both believe she always, as a maternal grandmother, has the children's best interest at heart.
Yes.
All right, so I'll just put that there. All right. And you're gonna split the kids for taxes.
Yeah.
And then when the oldest one falls off, then you'll alternate.
Yeah.
Is that right? All right.
Yep.
And you understand, at some point, Kimberly, the state could require you to add the kids to and have a family plan and insure them. And then that does affect the child support. If you're actually paying insurance on them, then Alexander, she gets a credit on the worksheet for what she pays for health insurance. Your proportion of that amount. So, but for now, they're on Kansas insurance. This is I haven't heard of this, the insurance before. What's the name of the program? Catch or?
Or is that the CHIP? It's the
CHIP?
children. I think that's what it's abbreviated.
Okay. Because I
It's the name of the
and
program.
it was something else, and now it's called CHIP.
Yeah, I mean,
Okay.
it's been like sunflower insurance before, or
Okay.
it's pretty much, I think it's child health insurance plan. It's meant
Okay.
for-
Okay. Well, anyway, you're ordered to split any unpaid medical, but usually when the state's paying, and if the kids aren't, real sick, if it's just standard kinds of stuff and immunizations and things like that, usually you won't owe anything. But if there is a bill outside of the insurance, you have to, instead of it being percentage of income, it's just 50-50, which I think is appropriate. All right. The court finds, after a review of the file and having heard from the parties, that okay, so you wrote down on page 19 that you would pay through Cash App $133 every Thursday.
Yeah, because we had spoke about, or Kimberly and I had spoke about that on the phone, and she said, I can't make, the way her bills are set up, she can't make a $530 payment. Like, that's like an
Okay.
entire weekly, she gets paid weekly, that's an entire paycheck.
Okay.
So we
Well-
thought, okay, that's a platform where it's recorded, but it sounds like you were saying they can split it up weekly and.
I really think I need to order this through KPC. It's just,
If it's,
I
if it-
understand what you want to do. But the problem is not only is it not an income withholding order, it's also not being paid through KPC. So, I mean, I guess the judge could look at a cash app, but see what happens is then somebody says, yeah, well, but I bought, you don't have kids in diapers anymore, but I bought formula and diapers. So I didn't pay her 133, I paid her 100 because she owed me 30. It's
Right.
too easy to get into this. Well, okay, this time it's only $90 this week because I paid it. And then you almost need to hire an accountant to go through all the records and books and make sure everything, it's just not how it works. That's-
Right, and it sounds like when
I'm
you
not
when you were
saying this
explaining.
is a bad idea or anything. It's just not how we do it. Okay,
That's-
so I'm gonna wipe that out and authorize an income withholding order and have it payable through KPC. So you both have to go online to www.kspaycenter.com to enroll.
Okay.
And then the child support worksheet gets sent to them. That's how they know what the court order is on child support.
And I will be preparing the Kansas Payment Center data entry sheet, as well as the income withholding order as part of my
Okay,
duties.
great. So we will make those modifications. So, if you'll have to contact the clerk to get a certified copy of your divorce decree. So that you can have it for legal purposes. You want to keep a record of it. And, there is a vital statistics form that you have to submit, that you need to make sure that you have and fill out and submit to the clerk's office. And so if you get this decree where we've made some changes and whited some stuff out and you think, hey, that's not what I understood was happening, or this isn't what, we thought it was gonna be, then you need to let me know. And, but I'm making the changes, basically my AA is gonna make the changes that I mentioned to you. So when you see changes on here, that's why, but if there's something that you don't think we discussed or something, let me know after you get a copy of the decree. It's not going to be filed today. I am out of town until, late this afternoon. So I'll be back in the office in the morning, but I also have a trial starting for 2 days, first thing in the morning. So my AA will be busy, but it will be filed this week, and it's not effective. It's until the journal entry is filed.
Okay.
She has to upload it electronically. And that's when it's official. That's when your divorce is official. And then there's a 30-day waiting period that's an appeal period. And it's a time in which, just like the 60-day waiting period before you can actually have a judge grant divorce, there's a 30-day waiting period after where you're not, you don't have the capacity to marry someone else. So I have to advise you, there's a waiting period to remarry. All right, as I indicated, the court has jurisdiction of the parties in the subject matter. 6 days has elapsed since the filing of the divorce. The parties are bona fide residents of the state of Kansas 60 days prior to filing. They've entered into an agreement to divide assets, primarily real estate, which is awarded to the petitioner. Their individual debt, of course, they are retaining, and any debt they've incurred since their separation in March of 2024. They've divided all of their personal property, and the court finds that this division is fair, just, and equitable. Additionally, they've entered into a parenting plan that the court will adopt that awards joint custody and a mutually agreed upon arrangement that appears to be in the best interest of the parties, but just as importantly, in the best interest of the children. And I will adopt the same. And last but not least, I find and I will award child support payable by the respondent to the petitioner, who is awarded primary residential custody. We don't really want to call it that. Nobody's superior to the other, but he is having them more of the time, so. But anyway, I am approving the parenting agreement and, ordering the child support pursuant to the worksheet and, payable pursuant to law through KPC and authorize an income withholding order. Last but not least, I find that the parties are incompatible with their reconcilable differences, and thus I will grant an absolute decree of divorce. Okay? All right. Any questions?
No, Your Honor.
Mr. Andrews, anything I've missed?
Not to my knowledge, Your Honor.
Really, thank you for your time. You can always check with me if you've got something else going on. I appreciated you appearing.
That was my
But
pleasure.
I don't want to require it at all times because I know you have other things that.
May it please the court, State of Kansas Department of Children and Families by Alexandria Hawks.
Attorney Megan Story on behalf of the petitioner Thomas Ford.
Okay. And Ms. Panita, I always have to ask you that. I'm sorry.
You're close, Pineta, yes.
Opinion. Continues to be self-represented. I don't know if you've ever had an attorney, have you?
No,
Okay. All right, so are you aware of what this, well, you are because it's been asserted that it's by agreement that you both want to terminate and agree to terminating the income withholding order.
yes,
Okay. And so Ms. Story, this is your motion and you filed a memorandum. And I guess the wording of the statute isn't so much that I have to find exceptional circumstances, but just good cause. That isn't a super high standard, but to not issue an income withholding order. But since this is a 4D case, so when the state has some involvement, then that they follow their rules and regulations and require that there be KPC payment and income withholding orders. Ms. Story, you've asserted though, Mr. Ford's business is such that it's detrimental to him and his income.
Yes, Your Honor.
And so Ms. Hawks, how do you feel having received the memorandum and the affidavit and the motion? Do you have a position? Because I didn't really see a responsive pleading from you.
Your Honor, I did not file one. It's the state's position still to have an income withholding order. However, something we could do, given Mr. Ford's kind of unique self-employment, where sometimes it looks like he ends up with contracts where he may be listed as a W-2 employee. What we could do is agree to put his income withholding order at 0 and allow him to make direct payments to the Kansas Payment Center. And then that way, if he has a W-2 contract with somebody and he pops up in the new hire system, if we put his income withholding order at 0, then it would not trigger an income withholding order to go to that new employee. However, the caveat with that is if he becomes more than 30 days in arrears, or if he becomes more than 1 month behind. So if essentially he gets to $500 or more in arrears, or he has arrears that extend, even if it's lower than 500, more than 30 days, we would want that income withholding order issued.
Okay, so I wondered about that because a lot of times DCF will do an IWO, but not know there was maybe not a current employer, or they don't know who the employer is or even where the person is, but they have one on file that they can activate when they need to. So I didn't know you did it at 0. I just didn't think that you filed it. I mean, it's in the court file, it's ready to be issued, but you just don't issue it. But you're saying you'll just go to 0, but you've got the authorization and then you can just modify it to the 500 and issue it if he is in arrearage?
Correct. So the way our system works, and because of federal regulation, we do have the ability to just issue automatic income withholding orders. Once we have that order and so, yes, if he became behind for more than 1 month of pay or more than 30 days, the system would just generate the income withholding order to issue.
Okay. Megan, I'm just not really familiar with getting W-2s and being, contract employee. My husband was a contracting engineer for a long time, and he either was self-employed or he worked for a contracting firm, and that's how he got a W-2. Obviously, you can always contract with somebody, and over the IRS amount, they have to send you a 1099, but I just really wasn't very familiar with a setup where you're working on a contract with someone and you're a temporary employee and they're giving you a W-2. I'm just not, unless it's a contract firm that you're going through, that they're giving you a W-2 because they're taking out taxes and all of that kind of thing. And you actually are an employee of the contract firm with the business that you're in contract with, but not a business that you're a temporary employee with. It's just not something I've seen. But anyway, I'm not going to really question that. I think that's a pretty good resolution to have it there, not particularly have it issued, but available to issue should he fail to make his payment. Can you agree with that? And I think that keeps them from violating their requirements as a 4D party to the case.
Your Honor, I believe that that would be a wonderful compromise. I do not, my client's only concern is, as we said in our memorandum, it going out to individuals that are not his technical employers, because then they ask him questions. Why are you behind on child support? It doesn't look very good for him. And so I believe that's a good compromise, Your Honor.
Right. Well, I've noticed, I don't know why, probably because there's a lot of pro se work being done in divorces and child support and that kind of thing, but we've gotten away from, the rule is to issue them. The rule is KPC, the rule is income withholding order. And the whole purpose of that was so that there wasn't any discriminatory sort of practice because someone had it. Because every business had to set up a payroll where they could do them, because 50% of the country is divorced paying child support. And so the more people that had it, then it wasn't something that was unique to a particular employee that then the employer's disgruntled with. I mean, that, to me, that was the whole purpose of doing it across the board, no matter how much money you made, no matter whether you paid yours on time or not. It was easy for a judge to see, and it made it so that it was something that was a practice that was acceptable in the industries as something that just par for the course. But anyway, I appreciate, Ms. Hawks, your suggestion. I think it's appropriate, as long as he does his job, which he understands what he will trigger if he doesn't make sure that he's making those payments. Okay. And I understand people don't like the court trustee fee, and I just had a case before you where they want to pay through Cash App, and that's, and I do understand that. It's just not the way it works. So, okay. All right. Megan, will you just journalize this?
Yes, Your Honor.
Or do you want to, Ms. Hawks? Do you want to just journalize it and modify your income withholding order, or how would you like it?
Generally, I offer to journalize because then it saves represented clients from having that extra expense.
Well, I would kind of appreciate that, because there was the motion memorandum took time and was very good and was appreciated and cost Mr. Ford some money. So if we could just. And I think an argument could have been made. I do, Megan, understand your argument in the journal entry. Hey, the judge didn't authorize it. She waived it. But I don't think I think if I'm gonna do that, I need to make an actual finding, a good cause finding, and that's the thing that we don't always do. So, and of course, there are other statutory rights. Again, the 4D case changes the nature of things. So, okay, very good. All right, everyone take care. If there's nothing further, we are the Jansen matter. Mr. Jansen continues to be self-represented. Kristen David Jansen, this is Greenwood County District Court case number 2021 DM 54. Kristen, now known as Graham, appears, the appearances are all by Zoom, appears by Zoom and with her attorney, Mr. Jansen. Marcus Meyer is the assigned domestic conciliator or mediator. And he submitted a report, I think, a pretty lengthy report, I think on Friday. I looked it over, but I'm not gonna say that I've read every page of this since I got it on the 26th, I think. By email, it's 40. Eight pages and then attachments and supporting documentation. Mr. Johnson, have you seen the domestic conciliation report?
Yes, I reviewed that this morning and discussed it with my client.
Okay. Does she have any objections to it? The parts that are additionally recommended that aren't agreed to?
Yeah, she objects to mainly the increased time in visitations. I think he's recommending the first, second, and fourth. It is a long document. And I was gone Friday afternoon, so I didn't read it till this morning. But I think generally Miss Graham objects to this is different than the one he had previously sent out. He had sent out a proposal not too long ago, and this changed that up some. I know Miss Graham has several objections to the recommendations of Mr. Meyer. And it might, if the court wants to know exactly what she's objecting to, it might be easier if I just ask her to advise the court.
Well, truthfully, there needs to be a notice of submission. Mr. Meyer, are you still doing those in Butler County based on our local rule?
It was sent Friday
Oh,
as well.
Okay,
Yeah.
so that's been filed. So I believe our current local rule is 21 days. To file an objection, because the objecting party generally has to pay for the testimony of the mediator if it's needed. And the criteria actually requires that whoever's objecting has to make an objection based on believing that there's something erroneous or inaccurate with the recommendations. And so
That probably, sorry.
so I'm Mr. Jansen, are you satisfied? Have you, I don't know if you've reviewed the report that includes the agreements and then recommendations on those things that you didn't come to an agreement to?
Yes, Your Honor, I went through the whole document this weekend, and I also am objecting to the recommendation for the parenting time.
Okay, so you'll have to file your own objections. And then I suppose if we need to call Mr. Meyer, you'll share the cost of his time and testimony. Or you know, you come up with something else like a agreed stipulation, then we'll figure out how to do an evidentiary hearing, you know, without incurring that additional expense. But I have to know what the specific objections are. And they have to be filed. And you have 21 days to get that done. So I'll set this out about 30, and I will have been able to review your objections. And I've looked at the recommendations. I quickly went through this. What I didn't do is look at the calendar. I mean, I haven't studied the supporting documents, basically. So I will, and I've been out of town this weekend in Kansas City as well, and I'm traveling back this afternoon after I drop somebody off at the airport. So that's why I'm working remotely, not from my office. So I will spend some more time on this and look at your objections when you file them. Make sure the notice of submission's filed in the court file so that triggers the time. If anybody needs a copy of the rule, be glad to forward it to you. And then we'll take the case up in 30 days and see where we're at. If you come to some agreement for some tweaking modifications without the necessity of a trial or evidentiary hearing, even if it's not quite the same as the recommendations, happy to entertain or approve that. But we are where we are. Mr. Meyer, do you have anything that you would like to add?
I think it might be helpful to share why we had a difference here in what this is compared to what the other document is that Ms. Graham is talking about, or Mr. Jansen. And that is because that was an attempt to reach agreements, and Ms. Jansen wanted, or Ms. Graham wanted to have Mr. Jansen have a lot less time, and Mr. Jansen wanted to have 50-50 time. So when we then did the investigation, we were trying to stay, you know, at a low budget. And, you know, at that stage, we had interviewed the school already. Some things have become more clear, and based on that is what this final document with a lot of pages. I agree. Usually they're like up to 30 pages, but a lot of work went into that, and I can share in good faith with both of you that you're paying probably about for a third of the time that I spent on this. So my objective has always been to do the right thing and, you know, to do something based on what was best for the parenting time for the children, not from what either parent wants, but what's best for the children and why we do that. So anyway, that's why that document is a bit different, not completely different. The agreements are the same. There are some adaptations to agreements that had to be made based on the recommendation. But other than that, there are some educational components that are recommended, actually strongly recommended, and some reading. So
Okay.
that's
I appreciate that. That's the first time I think that I've had an opportunity to see some of those recommendations about some ongoing parenting counseling, and how most of that could be done online, and what programs are available for parents to participate in. So I do appreciate that. But I'm going to give everybody time to digest all of this, and of course they have their legal rights to make their objections, and you know, they're entitled to a judicial hearing and proceeding, because these are recommendations but not tribunal decisions. And the rule sets all of that out, kind of how our chief judges drafted our rule related to conciliation, and the rest of us signed off on that. So that's kind of where it stands as far as the district's concerned, and it's I think it's pretty straightforward, so everybody can look at that as well. Decide what you want to do, and we'll come back together. And then I'll know what we need to schedule from there. So Bob, I have, but there's no reason for you to go back to Mr. Meyer. I mean, I think you either, I'm a believer that folks usually have an agreement in 60 or 90 days, sometimes within 30, and if they don't, they probably aren't going to agree. And once that happens, then I just need recommendations and we move on from there. And I don't see that you need to spend additional monies going back, because I don't foresee, unless there's something that gets tweaked between the attorney and you, Mr. Jansen, as being self-represented, to resolve not having an evidentiary hearing. I don't see that there's much need for you to go back to the table, given all that's been done. So, Mr. Johnson, I have October 27th, which isn't quite 30 days at 11, but it would be past the 21 days, I believe, at 11. Or I have the following week, which is Thursday, November 6th. That's just a little over the 30 days. And I have a 10, 10:30, and 3 o'clock on.
I could do 3. I've got a trial that morning in Coffeyville.
Okay, so I'm just gonna simply, I'm not going to set this as a pre-trial, as a precursor to a trial, because I haven't set an evidentiary trial for any of this at this point. So I am going to denote it as a status for announcements, and for me to review what's on file and acknowledge, you know, what's been filed. And that will be 11/6 at 3 o'clock, which is a Thursday, by Zoom. We will do it by Zoom again. And Mr. Meyer, you're welcome to appear. If you don't, that's fine too. Because if you're further needed, it's probably going to be an evidentiary hearing, well, where you will either be notified that we're having one, or you'll be subpoenaed to appear. Okay. Mr. Johnson, do you have anything else? Any questions for anyone?
No, I think it's pretty clear.
Okay, all right. Thank you, everyone, for appearing. If there's nothing further today, we are